now we're getting started.
Hi, everyone. My name is Michele Gartland, and I'm a partner at the Rucci Law Group in Darien, Connecticut. We're a woman-owned full-service law firm. We focus on corporate matters, business formations, real estate and zoning matters, as well as estate and trust creation and administration and probate court matters like guardianships and conservatorships. I wanted to thank HAYVN for organizing the HAYVN halftime presentations and for inviting me to speak today. This presentation is called Everything You Always Wanted to Know About Estate Planning, and it is meant to be a broad overview. But as we go through the topics today, if there are other topics that you'd like to get into on a more deeper in-depth level, please let me know and we can discuss having another one at a different time. And I'll also be offer some time for questions at the end. So with that in mind, let's go right to what is an estate plan. And sometimes an estate plan sort of sounds mysterious, but it really is very simple. It's an individual plan that's evidenced by a set of documents that indicates your wishes for asset administration and distribution upon death, and that also protects you during your lifetime. And I've done sort of a who, what, when, and why, and who needs an estate plan, and I've just said everyone. And although that might be a little simplistic, in many aspects it's true, and I'll get into why that is. But if you are over 18 years old, regardless of whether or not you have assets or not, there is an estate to administer, and there are reasons why you would want to have estate planning documents in place, and we'll discuss that. What constitutes an estate plan? Everyone is familiar with a last will and testament, and that really is the fundamental document, and that establishes who will be your executor. It establishes who will act as a guardian for minor children, and it also establishes how you want your assets distributed. Without this document in place, it really means that the court appoints an executor for you. It means that your estate is settled by the laws of intestacy and not according to your own wishes. And it creates delays and difficulties for those that you leave behind. The documents we're talking about next are what I call ancillary documents to an estate plan. And these ancillary documents are meant to take care of you while you're living. A power of attorney appoints someone to act on your behalf for financial matters. So if there's ever a time when you're hospitalized, you can't do things for yourself, it's important to have a power of attorney in place. And that's really for people of all ages. And I often recommend that people, not just have one, but have a successor. If they're in a car together and something happens, you always want a backup. Next is the appointment of a healthcare agent. And this is someone to act on your behalf while you're living. Again, I always recommend having a successor, not just naming one. And the other documents are an advanced medical directive. These are getting more and more attention as time goes on because people are, living longer, and some have very specific wishes. It's not just a living will. A living will is mentioned below, and a living will talks about medical interventions that you would or wouldn't want if you are having a terminal condition or are in a permanently vegetative state. But an advanced medical directive is even more encompassing and really talks about the type of care you would like to have on an ongoing basis. And finally, there's a HIPAA release form that designates, or that permits the individuals that you've designated to act on your behalf. It permits them to get access to your medical records so that they can make decisions. The when of an estate plan is, I think, as I said, sort of 18 and beyond, but it's really necessary for people at all ages and stages for different reasons, and can be and should be revisited periodically as circumstances change. Laws can change that impact estate planning. Relationships can change. So people that you might have appointed when you were 25, might be different now that you're 45. And your own personal financial situation can change that might require a second look at tax planning or other aspects of your plan. So I typically tell clients every 5 to 10 years, and you'll sort of know when circumstances have changed to the point where it makes sense. I mean, even if you just reread it, a lot of times people are surprised about what's in there and who's in there. So it really merits a garnering every once in a while. And why do you need a estate plan? This is probably the most important slide in this section. And because an estate plan sets forth your wishes, it's really your opportunity to have an impact on what happens after you die. It organizes your estate so the administration is clear for your executor. I mean, think about what would happen if something happened to you today. Like, where would they pick up the pieces? What would they do? And it also protects your beneficiaries. I think I mentioned earlier that without an estate plan, you're really sort of at the mercy of the court and the laws that are in place to how things will go. And the laws of intestacy might not be how you want your estate divided. If you have a spouse and parents, but no kids, the spouse gets the first 100,000, and then it's divided 75%, 25%. So with your parents getting 25%. That may or may not be how you want things to be. If you have a spouse and children, but no parents, the spouse gets the first 100,000, and then it's split 50-50, the spouse and the children. So again, there's a lot of things that you might want to be different than that plan, and it makes sense to set that up. By thinking about an estate plan, you also have the opportunity to review designated beneficiaries and think really carefully about how that impacts your estate plan. And we'll talk about those type of assets later. In general, without an estate plan in place, you're talking about an estate settlement where the process will be longer and it'll be more expensive. If I've done my job right, essentially, when it comes time, when someone passes away, it's just a process, but there's not the anxiety around it that there would be if there wasn't a plan in place. And then, finally, another aspect of it is guardians. If you haven't named guardians for your minor children, they're in a state of limbo, and that's what you want to avoid. If you have kids, you want to make sure that they're safe and secure, and the people that you want taking care of them have been identified by you. So the next slide is how does an estate plan protect loved ones? And in the process of creating an estate plan, all aspects are considered, from the simple to the complex, to make sure your family is protected. And topics that we would typically review include tax planning, and that encompasses a lot of different aspects, but we want to take a look and find out if your estate will be subject to state or federal estate taxes, and if they are, how to prepare. And I wanted to give you a brief overview of what those numbers are. At the federal level, currently, it's very generous. In fact, at the state and the federal level, it's very generous. At the federal level, it's $12,060,000 in 2022. This goes up for inflation every year, and for a couple, it is compounded. It can be combined. So you're looking at the federal level of, $24,120,000, which is a big number. And if you exceed that number, you would be paying tax at a rate of 40%, which again is significant enough that people want to make sure they avoid that. The law that put these kinds of numbers in place sunsets at 2025. It means it expires according to its terms, but we don't know whether or not it'll be extended in legislation. There was a lot of conversation in the fall with Build Back Better that it might have been reduced at that time. Right now, it is scheduled to go down to $6.2 million per person. And again, that can be combined. So it would be slashed in half. And on the Connecticut side, we're up to $9.1 million in the state of Connecticut. Just 5 years ago, it was about $2 million. So things have improved substantially. The tax rate in Connecticut is about 12%. So it's not as significant to the federal, but it still all adds up. And next year, the Connecticut exemption amount sets to the federal. So that's a positive, but again, that federal number is set to sunset in 2025. So we just don't know what's going to happen after that, both federally and on the Connecticut side. The other thing to point out on the Connecticut side is that's a per person number and it can't be combined. So we do some tax planning for that, because if you leave everything to your surviving spouse, they only get their own $9.1 million. They only get their own exemption amount. So we want to plan for that to take advantage of each person having their own exemption amount. Next, we take a look at life insurance and whether or not you have it and whether or not you want it. And I always think of life insurance somewhat unfairly because I never get the benefit of it. I don't feel like it's my asset, but it is. And, you know, if you're trying to plan an amount where you're taking care of your family and if you're, you know, very generously insured, that amount lands in your estate and counts as your asset and therefore could be taxable. You know, that one asset could put you over a taxable amount. The other thing that I want to point out is, you know, one of our most powerful tools for passing on wealth, actually, at least initially, is the marital deduction. So anything you leave to your spouse will not be part of a taxable estate for the first to die. But that, you know, also has to be tended and cared for to make sure that you get the tax benefits of each person's exemption. And I'll point out that if you are married to a non-citizen, that they do not get the benefit of the marital deduction. Yes, it's important. You can plan for that. The idea behind it is they don't want your non-citizen spouse to leave the country and not pay tax on the amount that they've inherited. So we can set up something called a qualified domestic trust. But, you know, again, it's something that should be thought about and planned for if that applies to you. The next part of what we look at in an estate plan is what are probate assets and what are non-probate assets, and how does that impact your estate planning. So for, you know, in the most simple terms, a probate asset is an asset in your sole name. It does not have a beneficiary designation, and therefore it will pass through your will. A non-probate asset passes by operation of law or by beneficiary designation. So examples of non-probate assets are your home that you might own jointly with right of survivorship. And by operation of law, that home will be transferred to the other person on the deed. Another example is a life insurance policy with a designated beneficiary. And another example is an IRA or a 401k that has a designated beneficiaries. And sometimes I meet with families and all their accounts are joint. The home is joint and their primary assets are 401ks and IRAs. And that's wonderful. That will definitely eliminate probate for the first to die, but it means that no assets are passing through the estate plan. So to the extent that you wanted to set up trusts for minor kids or anything like that, we've unintentionally circumvented the plan. So we'll take a look at that and figure out how best to organize it so that you still have a non-probate estate, but that you've added in the protections you want. Because for children without a trust, they will receive outright at 18.
I have a question, Michelle. I have a quick question. So an IRA account needs to get delineated as to who the beneficiary is at your death in your will.
No. So if you have a designated beneficiary, no matter what's in your will, the designated beneficiary is the last word. What, you know, whoever holds the IRA is the last word. So, you know, again, sometimes someone has an IRA from when they were young and they've named their parents and now they're married with kids and they haven't bothered to change the beneficiary designation. You know, mom and dad are going to get that instead of the surviving spouse and kids. And similarly, if you don't have a designated beneficiary, then it's going into your estate. And the shame about that is unless you've made preparations, the person doesn't get the benefit of having an inherited IRA. I mean, the inherited IRA is a powerful tool because it allows for deferred tax status for, you know, an additional 10 years in most cases. For a surviving spouse, you're still permitted to do a stretch IRA according to their lifetime. The Secure Act changed that for most designated beneficiaries, but not all. So there's still some opportunities for, you know, to get the maximum benefit of a tax deferred IRA. So you wouldn't want to lose that. And And for minor children, obviously you want to put in place a trustee to care for them in the event that both parents have passed away. You'd like to make sure that that person, again, is someone who you trust with financial matters, someone who you believe would keep in mind how you'd want to raise your kids. They'll be responsible for distributions to your kids. And then you think about at what ages and stages and in what percentages do you think you want to make that money available to your children outright? And again, that's a very individual parental decision that gets thought out and discussed. Some parents, take it one step further and they think, oh my gosh, if my child's inheriting a lot of money, how do I protect it from becoming a marital asset? What do I do now to make sure if my kids get divorced, that my inheritance won't be subject to division? And these are all things that we talk about. And then the last one is, again, as we mentioned, who will take over your finances or affairs if you're not able to do so? Who do you appoint as the executor? How will they know what to do? And everyone should have a list, which we'll talk about in depth later, of contacts and resources so that someone will know what to do. I wanted to briefly go into the topic of what are trusts and why are they beneficial. It's sort of a quagmire, and a lot of people hear terms and don't necessarily understand what they mean, but this is a basic definition. A trust is a right in property, real or personal, which is held in a fiduciary relationship by one party for the benefit of another. So there are usually three parties involved. The grantor is the one who grants the property to the trust. The trustee is the one who holds the trust property for the benefit of the beneficiary, and the beneficiary is the person who receives the benefits of the trust. There are, among all the different types of trusts, there are two fundamental types. One is called a revocable or a living trust. And the next slide will be the irrevocable trust. The revocable trust, I want to be clear, is not a wealth transfer vehicle. In general, the person who sets up the trust can be their own trustee. They have ultimate control and flexibility. This trust can be amended, it can be restated, it can be terminated. The person has the ultimate ability to change this, and it's very popular because of its flexibility. But on the other hand, if you are doing intensive tax planning and want to get money out of your estate, this isn't it. It generally is under people's own social security number. And the reason people like that is because they have control over their own money while they pass away. But similar to a will, they can decide how it's distributed. By having it under their own social security number, they can get a step up in basis upon death. So it's not like they've gifted it at fair market value on one day. This comes up with a home all the time. Your parents or older people purchase a home that's appreciated in value. When someone passes away, it gets distributed to their heirs at the date of death value. So the step up in basis, the ability to have that step up in basis, is one of the tax code's most favorable benefits that applies to the most people. It really is, that in itself is a transfer of wealth, and it's a way to essentially avoid capital gains, because it circumvents the need for capital gains because the heirs will assume the property at the date of death value. The reason that a lot of people like revocable trusts is, again, they have control, so they haven't given up control of their money, but it allows for privacy. Part of our probate process is that the will is submitted for probate, and it still should be an original document. If it's not an original document, you have to get an authentication process, which is a little bit more cumbersome, but we still like the original will to be submitted to probate. And if all your dispositive provisions are in that will, then that's public information. So if you just say that your will essentially pours over into your revocable trust, then that distribution is private. No one needs to know. And the last point on the slide is that it can help lessen or avoid probate. So if you go through the exercise of retitling your assets and put them in the name of the revocable trust, then all of the assets are non-probate assets because they're not solely owned by you, they're owned by the trust. And again, you've had control over them. I say can help to lessen or avoid probate because it's all about the commitment that the client has in retitling assets. So generally, if you have a brokerage account, that's super easy. The brokerage firm will take care of that for you. But again, by having the assets titled in the name of the trust, none of them are solely owned assets, and they can avoid probate. And I just wanted to take a moment to talk about probate. Probate's not the end of the world. It is a process, but it can be accomplished. It does add some length and expense to the process. In the state of Connecticut, any estate any estate with probate assets over $40,000 is a full estate. And that means you get an executor appointed, you do the tax returns, you do a final accounting, everything goes through the court in a process. And with 40,000 assets of 40,000 and less, that's called a small estate, and the process is more expedited. And then finally, there's something called for tax purposes only, a TPO. And if it's for tax purposes only, what you're down to is submitting an estate tax return to the state of Connecticut, and everyone has to do that. And everyone also has to pay a statutory probate fee. And that fee is on your gross assets, whether it's held in your sole name or in the name of the revocable trust, because in that context, you still had control over those assets. You haven't given up control. It's still under your social security number. But the statutory probate fee is really a fraction of estate taxes. It starts out at like 25 basis points. So it's not as cumbersome, and it is something that the state requires of everyone who has to submit an estate tax return. So irrevocable trusts are next, and this one is a wealth transfer vehicle. You are giving up title, you're giving up ownership and control of the assets that you put into the irrevocable trust. The grantor and trustee generally cannot be the same person. There's one instance where they can, where the amount that can be distributed is limited to an IRS ascertainable standard, but in general, the sanctity of the trust is better preserved if the grantor and the trustee are two different people and independent of each other. It's a separate legal entity and should have its own tax ID number. Irrevocable trust can be used for a variety of purposes, and I've listed, they can be used for a variety of purposes. One of them is irrevocable life insurance trusts, which I touched on before. If the life insurance policy is owned by the trust, then it's not part of your estate. Trust can be set up for minor children. There's something called the spousal lifetime access trust, domestic asset protection trusts. Those are very popular with doctors and professionals who are concerned about liability issues. Charitable remainder trusts are a way for you to have an annuity but get benefits of tax deductions for contributions to charities. Dynasty trusts are ones that are meant to last generationally. And then there's something called the grantor retained annuity trust, which again is used for a variety of purposes. All of these trusts are kind of beyond the scope of today's presentation, but they all have different characteristics and different purposes and can be quite helpful in certain situations. Oh, and I guess one of those that didn't make it on that is a special needs trust. And that's also a very important irrevocable trust if you have a child who's receiving government benefits and you don't want to jeopardize those benefits. For this audience, I wanted to include a slide of how does owning a business impact your estate. And one of the things to think about is, do your operating documents permit transferees? So in your estate plan, you can leave all of your assets, which would maybe include your LLC membership interests. It can include all of your assets, but then you find that under the operating documents, a family member is not a permitted transferee. that would be unusual, but it is something that you should check out and make sure that your business operating documents can complement your estate planning. You would want to make sure that your family member can be a permitted transferee and own a share of your business. Or if you and your partners decide you wouldn't want a family member to be a part of the business, there should be a buy-sell agreement so you can identify a process and you can make sure that your heirs are compensated for your contribution to the business. Another aspect of having a business that might be privately owned is, maybe getting a key man life insurance policy. So that would mean the business pays for the policy, the money would go to the business upon your death, and then the business could then buy out your family. And you also might consider life insurance personally if you think that the business is worth an amount such that you'd have to pay a state tax on an illiquid business. So you're trying to provide a liquid source of funds to pay a state tax for your business. Finally, I'm going to go to an aspect of the presentation which is less legal and more practical, and it's what you should have prepared so that you can be organized in the event that something were to happen to you and someone would need to step into your shoes. And it's sort of a level of organization that I have to admit I don't have myself, and it's kind of tedious to put together, but I can't overestimate how important it is for people to take the time and really pull the information together. So, what I would recommend is a letter of instruction kept someplace safe, and you would list all your assets, you list how they're titled, you let people know where tangible assets are, you provide information about all of your liquid assets like bank and brokerage accounts. And this is sensitive, but including passwords and PINs, so someone can hop on and do what they need to do. I should also mention that a power of attorney, which is what a relative would use on your behalf if you fall ill, that power of attorney ceases to have any force and effect once you've passed away. So then you need to go to an executor. That's the power who would then be able to act. And if you do have your assets in a revocable trust, if you have a successor trustee, they would be able to act right away without having to be appointed. So that's another aspect of having a revocable trust that's very handy. I went to a seminar yesterday about cryptocurrency, and that was sort of mind-boggling how to get your fingers on that asset. But digital assets are another topic that are important. And it's important to figure out, what those assets are, how to track them down. What are the movies in your iTunes account and how many movies you have? I mean, that might be worth money that you would want to be able to pass down. I know I have all my photos in the cloud, and I certainly would want my kids to have access to our photo library. So they would need to know passwords and how to get at that stuff. This is more information to include on that letter of instructions, like names of contacts that can be very helpful to family, any charities that you'd like to be recognized, locations of documents, a list of your designated beneficiaries, but by far that should be registered with the individual accounts. That's even more important than having it on a piece of paper. The location of all safe deposit box and keys. And I really want to say that the worst place possible to have your will is in a safe deposit box. Because oftentimes people don't know where the keys are. And in order to access the box of a deceased person, you would need to have the authority to do so. And the ability to appoint an executor is buried in that box in your original will. So, think about that and try to think about what people would need. And again, sort of all contact information for insurance, for mortgages. I mentioned digital accounts, but that's, this is basic information and it's a lot, but it would be very helpful. This slide is one that deals with specific assets, and it's tangible personal property, and I call this the stuff. What happens to your stuff? And you may or may not be surprised about how often that comes up as a point of contention among beneficiaries, is who gets the stuff, who gets mom's engagement ring, who gets the Picasso. And that can be specifically listed in an estate plan by item. I would recommend that. Most of my, all of my documents have the ability to have a memorandum that's recognized, but that memorandum should be dated. Ideally, it should be in the will. If the will doesn't refer to a memorandum and just has assets being distributed evenly among kids, but you have a separate, piece of paper that says, I want the Picasso to go to Judy, that's not going to be recognized because the will says that it gets split evenly unless the will refers to a memorandum of wishes. And finally, I've listed other things that you might not think about, like a frequent flyer account. There's value in that. There's value in membership rewards. Those can be passed down, but your heirs would need to know how to find them and what they are. This one about funeral and burial instructions is really important. I'm doing a presentation for the Archdiocese of Bridgeport, and they're doing a legacy gift planning presentation for their members, and letting your family know what kind of end of life ceremonies and services you want is important. Next is our summary. I know I covered a lot, but I just wanted to kind of highlight what I think is the most important, because the estate plan really is a plan designed by you, and it takes care of you while you're living through these ancillary documents, and it takes care of your family by really setting up how you want them cared for and how you want your assets distributed. I view it as a really important opportunity for you to have control over how this process works. And by doing things proactively, creating these letters, creating a roadmap, it really makes a positive difference for your executor and their family. I view it as a gift to them by helping them through this process. And by planning now, you reduce the risk of uncertainty, because you know that the people that you appoint are the ones who are going to take care of things, and it does save money and time down the road. So those are the major points for my presentation. I would like to open it up for questions. And again, if there's been any aspect of this presentation that you would like me to go into more depth on another occasion, please let me know, and I'd be happy to do so. So there's one question in the chat. How do trust funds set up for minor children impact applying for financial aid in college? That is a great question. And I actually don't know the answer, to the extent that I don't know if there's a question specifically about that. I know that trust funds are not in the name of the child. They're a separate entity. So if it asks, is there an income stream from a trust, that may or may not be true. So most trusts can be set up where it's at the discretion of the trustee. And if it's at the discretion of the trustee, that means that it's not a guaranteed income stream. So I think you would be, if that question's on a form, you may be able to answer that question no, because it's not, if the terms of the trust are not a guaranteed income stream, then no. But I wish I knew more, and I will try to find out more about what type of questions are asked on the financial aid form and how that would apply. Yeah. So that's another great question too. Is the estate plan accepted in New York and New Jersey if it's written in Connecticut? And are these state by state, and do we need to redo if we move? So ideally, it would be accepted everywhere. Our estate planning laws have reciprocity in most states, as long as the will was validly executed in its state of origin. So in Connecticut, a will has to be witnessed by 2 individuals. And then we do a second authentication process of having those 2 witness signatures be notarized. But actually the law just says 2 witnesses. So as long as a will was validly executed in the state of Connecticut, it should be honored in New York or New Jersey or anywhere else. The only occasion where I would say you really should look at your documents if you move is if the laws are substantially different. Maybe it's a community property state, and that would be different. Some of the things we might set up in Connecticut, like something called a credit shelter trust, because we've got this estate tax that is a per person. If people move to Florida, you wouldn't want to set that up. There'd be no need because there's no Florida estate tax. So, as part of that every 5 to 10 year review process, if you have moved, it might make sense to ask local counsel at that point if these documents still work and are still, the most advantageous plan for you. But in general, it works both ways. If a Connecticut document is submitted somewhere else, it should stand up. Similarly, if a New York document was done and the person is a Connecticut resident at the time of death, that will be honored in the state of Connecticut.
I have a question.
Yes.
As children age out of, 18, 21, if you have guardianship in your will, do you need to change it? Or is it just like once they're over 21, it's disregarded?
It's just disregarded. So you don't need to change your will just for that.
Okay.
But for the over 18 crowd, I really do encourage people to put these ancillary documents in place: a power of attorney, the appointment of a healthcare agent, and a HIPAA release form.
For them?
For your 18-year-olds. And that's why I say everyone should have an estate plan. Because when kids go to college, they're adults. And, I can't tell you how many times I've heard of, accidents happening, parents not being able to get the private medical information of their adult children. And it's something that we just take for granted, right? We've taken care of them all of their lives. But, once they get to college, you need permission to act on their behalf. So we think this is so important that we have a program at our firm to put those documents together for $250. And we just want to make sure that everyone who has them needs them, and it's just in the back pocket, and hopefully you won't need them, but it helps protect the kids, no doubt about it.
And what are the 3 forms? HIPAA release, power of attorney.
An appointment of a healthcare agent. That's probably the most important.
Yeah. And where does the HIPAA release form, does it reside with a copy with the college?
It can, sometimes colleges will submit that, will give that to you themselves as part of a packet, but then the college has it, and it's not necessarily something you have for your general use if you need it under different circumstances.
Mm-hmm.
So we prepare them, we can give you digital copies, we give you one set of originals, and it's just sort of available if you need it. Any other questions?
Can you repeat those again? What are the things that we need for the kids?
I think I hit a nerve. I don't think it's anything that's ever registered.
Yeah. So I think that what's important to have is the appointment of a healthcare agent, and then a HIPAA release form. And I include the power of attorney because they're going to be young adults. They're going to have their own bank account. If you need to access those funds for any reason, if you need to pay bills, for them when they're working in the city or something, and you need access to their account to do that, then that's something you have in your back pocket. It's there in case, right? So much of what I do is there. It's there in case you need it.
Appointment of a healthcare proxy. I'm trying to write it down.
Well, appointment of a healthcare agent. It can have a lot of different names. Yeah.
Okay. Power of attorney and HIPAA
release form.
Okay. Okay.
Part of the standard documents that we do for adults, is those 3 plus a living will. And, you know, a lot of times when I'm sitting down with an 18-year-old, the living will is a little bit more than, you know, they can think about or digest. And that's totally an optional form. But a lot of times it does give parents an indication of what the kids' wishes would be.
Okay. Okay, thanks.
Yeah,
And
of
the
course.
child would initiate this, or can you do it on behalf?
No,
So
it
the
had, you
child-
know, the child, I can't get those forms signed until the child turns 18 and they have to physically sign them.
Did you talk about, sorry,
No, go
you
ahead.
were talking about how much something like that costs, but how much, like, what's the range for this to work with a lawyer? To
Just
get,
repeat the
like,
question.
did you already talk about that?
No, we haven't. So the question was, you know, essentially how much does an estate plan cost? And you were just about to ask that. Okay, great. So, you know, the answer that I have to put forward is that it depends. It depends on the complexity of the plan. More and more, we're trying to offer our clients a flat fee so they know exactly what to expect. And that fee can be discussed once I have a sense of the documents that they need and where, you know, if it's a person for a plan for a single person, a couple, if it involves estate planning and multiple trusts. For something like an ILET, for instance, a standalone trust is $2,500. An estate plan is usually in the range of $3,500 to up to 5,000, but yes. And it, you know, again, it depends on how many meetings there are, you know, but I try to make sure that people know what they're getting into and can plan for that. Oftentimes I'll start with someone, and recently I've started to put in my engagement letters that it's this flat fee as long as it's done within 6 months. Because, you know, initially this isn't something that anyone really gets to, and then it can be put on the back burner, and then I have to familiarize myself with it all over again. So we lose a lot of efficiency, and generally 6 months, you know, should get us all to focus, and it can be completed within that time. How long is the process of doing the medical items? The ancillary documents for kids can take a couple days, within a week. You know, we try to be really respectful of the kids' schedules. Some of them are, you know, only around for vacations. But if we get the right information, the comprehensive information for who they'd like to appoint, along with the contact information and cell numbers, we can put those forms together very quickly.
And they don't expire like a passport or
No,
anything.
they don't expire, although I will say that for these ancillary documents, we encourage people to review them every 3 to 5 years, mostly because banks and healthcare organizations tend to want documents that are fresh. And again, they're not expensive to produce, but you know, I can't tell you how many times you know, we've been asked by clients, they've been given a hard time by a bank or a medical institution because they're considered stale. But in the absence of nothing, then then they will be honored.
So you just present them if you have a problem. Otherwise, you don't need to submit them anywhere.
No.
They're not
Exactly.
filed with a court or with the bank. You don't have to send it to the bank. No,
Right.
it's just for
Exactly.
your own. You like
Yes.
to kind of walk in and show a badge.
Yeah. Yes. And you know, you can keep them in a drawer until they're
Right.
needed. You don't
Right.
have to, you know, give someone a financial power of attorney until the point where you feel like you need it.
Michelle, I have a question. If you have something with another firm, and for example, if I want to work with you, the new one overrides the old, like
Yes.
it just
Yes.
yeah.
If you do a new will, that will override the other one. For clarity's sake, it's always a good idea to get the original documents and shred them so there's no confusion. And I always suggest getting the originals, and I look at each person's plan to see if a new one is really needed or is just an amendment needed. Is it just a codicil? That kind of thing, so that we're doing things most efficiently for you.
The original, you mean like when you set up, they send you one, like the hard copy I have?
Yes.
Or you have to reach out
Well,
to-
sometimes firms keep them in their vault. I know we do for our original wills. So you get the originals from them. If you have the originals, it's just probably better for clarity's sake to only have, one original so that everyone knows which is the one, but the one that is dated the most recent will be by default viewed as the one in full force and effect.
So, question.
Mhm.
If you have a 30-year-old child and suddenly they die, and they don't have any documents, and they have an estate of, $100,000 or whatever, what happens to all that?
So the question was, if you have an adult child, in their 30s with some assets and no will, and what happens with that is you will go through the probate process because it's over $40,000. There are documents that will help you through the process that we submit to the court, on your behalf to get you appointed as executor. And then it will be passed by the laws of intestacy. So, assuming he's not married and has no kids, it all goes to you.
Okay, but by having these 3 documents you talked about, it just makes it a lot easier.
It does.
Okay.
Yeah. I mean, things are basically on pause, like there's no power of attorney anymore.
Right.
And you don't have the ability to act as executor. So you try to minimize the amount of time that things are in limbo. And it just takes longer without a will.
All right, we're about 1 o'clock. I think what we'll do is, for those that didn't get the slide presentation, I can circulate that. Michele had sent it to me, so I can circulate that. And I'll put her contact information is on the slide, and you can reach out to her directly with any questions or follow-up.
Yeah.
Yes.
Thanks so much for attending. Thank
Yes,
you.
this was great. Thank you so much.